So this video is about how a married person who writes a will and leaves the usufruct to their spouse should consider leaving the naked ownership in trust for the benefit of the naked owners. Hey, I'm Paul Rabelais. I'm an estate planning attorney helping families around the country, around the state, get their legal affairs in order and making sure things go smooth when somebody passes away. And when someone puts their legal affairs in order, they typically leave things to their survivors either through a living trust in an attempt to avoid the probate or succession, or they leave their estate to their survivors through their last will and testament. Now, when a married person chooses to leave their estate to their survivors through a last will and testament, they often either leave their spouse the ownership. I leave my entire estate in full ownership to my spouse. Problem with that is the surviving spouse then can really disinherit the children, leave things to a second spouse, so there's no protection for the children of the first spouse to die. So in many cases, when married people write wills, they say they leave their spouse the usufruct, and sometimes it's the lifetime usufruct of their estate to their spouse, and they name often their children as the naked owners. Sometimes they might say their children and their grandchildren as the naked owners to get the assets when the surviving spouse passes away. But when that's the case, sometimes things can be difficult to accomplish later. Let me give you a couple of examples. One, husband writes that will, leaves his wife usufruct, names the kids as the naked owners. Husband dies. Now the succession is necessary because assets were left in the husband's name. Those assets are frozen. You have to use the will to go through the court proceeding to get things transferred, get the husband's name off of the title of the home and other assets. So when the husband left the usufruct of his estate to his wife and named his kids as the naked owners, now all of those people have to be participants or petitioners in the succession. And sometimes that can be a little bit difficult because now, the succession can be complicated. The court pleadings are complicated. You've got the surviving spouse and all of the children as participants, and sometimes they don't fully understand all these usufruct naked ownership terms. And when they're a participant in the succession, the more people you have, the more complicated it gets. Also, if the children are participants, sometimes they get a little nervous because you're talking about their future inheritance and they want to make sure it's protected. And then sometimes you have, siblings, as unfortunate as it may be, who don't get along or who have spouses who have influence. And sometimes the succession can't even be completed because of all those different personalities that are at play. So when you leave the usufruct, naked ownership to the kids, all those people have to participate and sign off on and agree on all of the succession pleadings. And that's potentially a problem. Now, if you get through the succession, it moves on to problem number 2, which is, let's say that surviving wife decides to sell the house, time to downsize. Well, all of the people who have an ownership interest in that house have to sign on the purchase agreement and the sale. And when the husband left his wife the usufruct and he named his kids as the naked owners, even if he granted her this right to dispose of non-consumables, they're going to require the children to sign off on all of that real estate sale paperwork. And sometimes that gets difficult because the naked owners, the children, sometimes have a false expectation that they're going to get money when the house is sold, even though they're not entitled to it. Sometimes naked owners want to make sure their future inheritance is protected, so they don't allow that surviving spouse to sell the house. Again, sometimes spouses and children of naked owners get involved and it causes problems. And again, so you've got too many people involved in the subsequent sale of a home or piece of real estate. So one potential solution is the husband could have written his will a slightly different way. He could have said, I leave the usufruct of my estate to my spouse. I leave the naked ownership to my children, but that naked ownership after I die shall be held in a testamentary trust with my surviving wife as the trustee. So he still named his children as the naked owners, but he said that naked ownership will be held in a trust with the surviving wife as the trustee, and it'll last for the rest of his surviving wife's lifetime. What that did was it made it easier to complete the succession, and it made it easier to sell the home and other properties. So when he dies under that different way, now the only participant in the succession is the surviving wife. The naked owners aren't involved because the surviving wife still owns her half. She has the usufruct of his half, and then the naked ownership of his half is going to be in trust with the surviving wife as the trustee, so she can sign all of the succession paperwork on behalf of the naked owners because that naked ownership is in trust and she's the trustee. So it makes it a lot easier for the succession to be complete. And then now when she wants to sell the house, she's the only participant to that sale because, again, she'll be signing to sell her half of the home. Her husband's half, she has the usufruct. The naked ownership is in trust and she's the trustee, so she can sign all of that paperwork on behalf of the naked owner. So that's just another way to consider leaving. If you're gonna leave a will and there's gonna be a succession when you die, that's a way to make it easier for things to get done. Now, note that if you're gonna set it up that way, you're gonna have to work with an attorney who has at least a certain level of estate sophistication regarding trusts and naked ownership and trust. Not every attorney does that on a daily basis, so you have to work with one who at least has that basic level of sophistication. But it's something that should be considered when you're arranging your affairs. If you're not leaving things through a trust, many people do. You're leaving things through a will, going to require the succession, but set it up. If you're going to go that route, set it up in a way that's not so cumbersome for so many people after you pass away and if something needs to be sold. So hope that helps. The key here is get started, get it done the right way the first time, work with somebody who you feel comfortable understands all of these issues, and you'll go a long way toward making things simple for your family and leaving a legacy behind. Hope all that helps. Subscribe to our YouTube channel. That'd be a big favor to me. We'll keep making sure that you get really good information as we continue to produce more information through these videos. Y'all have a great day.